Welcome to Court Helicopter News, our normal weekend explainer. And today's explainer, we are comparing what happened in Tanzania, where the president-elect of Tanzania, Mama Samia Suluhu, was declared the winner and was sworn in, not in public, in a military installation without the public being present. That is the law in Tanzania. What is the Kenyan law? Let us look at the Kenyan law, and that law is found in Article 140 of the Kenyan Constitution. That is, after the IEBC has conducted an election and a person has been declared a presidential elect, all the candidates who go to the ballot in 2027, including His Excellency the President of the Republic of Kenya, gets a title of candidates for the purpose of election. Once one has been elected, whether he is a sitting president, whether he is an opposition candidate, that person is called a presidential elect. So upon IEBC declaring the results and putting it up, one has, under Article 140, 7 days to move to the Supreme Court to challenge that petition, that election. The 7 days start running from the day the pronouncement has been done. So if 7 days elapse before one files a petition, then the process of being sworn in starts. But if there is somebody who has gone to court and file a petition, that petition to challenge the validity of the election of the president serves as a stay. The president-elect cannot be sworn in. The president-elect will not proceed to Kasarani to be sworn in. The Supreme Court, after receiving the election petition, will order it be served, and the hearing of the Supreme Court, hearing of the election petition, will commence, and a final decision must be concluded within 14 days. There can never be an extension of the 14 days. The petition will continue day to day, and a decision shall be done. That decision is final. Nobody can challenge the decision of the Supreme Court, because this is the apex court that nobody can follow or challenge the decisions coming from the Supreme Court. In light of that, let me explain the hierarchy of the courts. Under the Kenyan law, we have the Supreme Court of Kenya. It has original jurisdiction, alone exclusive jurisdiction to hear presidential election petitions. You don't go to the High Court, then you go to the Supreme Court. You go directly to the Supreme Court. So the jurisdiction of presidential contests is vested on the Supreme Court. The other courts that exist in this country are the Court of Appeal. There, in the Court of Appeal, which we'll be looking shortly, the judges must sit at least a minimum of 3 judges, a maximum of 5 or 7. In the Supreme Court, the quorum is strictly 5 judges. There can never be a quorum unless the Supreme Court has 5 judges. The maximum number of judges are 7, including the Chief Justice, who holds the position of the President of the Supreme Court. So, presidential petitions are purely filed under the jurisdiction of the Supreme Court, and their decision is final. Let nobody cheat you that you can go to the East African Court of Justice to challenge the Supreme Court decision. You can't go to the ICC. Remember, there is no decision from the Supreme Court on presidential elections that can be challenged. That is the court explainer, and we shall be moving to now, in the next episode, how does the president who has been cleared by the IBC or by the presidential petition court, the Supreme Court, proceed to be sworn in? That one is in Article 141 of the Constitution of Kenya, as we juxtaposed it together with what happened in Tanzania. Wakili Danstan Omari from Milimani Law Courts. Thank you.